were you conned to buy a property not fit as per the prospectus that you are given? Can you redress what you are doing? Many people have bought these sectional properties, apartments for business, Airbnbs. Your customers come in, there is no Wi-Fi. Your customers come in, there is no cleaning facilities. Your customer comes in, there is no water, hot water. Your customer comes in, there is no light. The windows are so small. Your customer comes in, the garbage is falling from top to where you are. We shall bring to you. Court and Copter will always bring to you the law as it is. Welcome to Court and Copter Explainer, where we are looking at homes, what we call the Sectional Properties Act. I want us to look at the historical perspective to a house or a home. Originally, Africans owned grass-thatched houses. Those who had grass-thatched houses and mud houses, the number made them rich people. The concept of homes was that traditional home. Later, the second concept of home was semi-permanent homes, where a mud-walled house could be plastered and that became a mansionette, a very big home. The third concept of home became brick homes built by traditional kienyeji matofali, and it was called a permanent home. By the time the semi-permanent houses and brick homes came in, we now started having iron-roofed roofs. Those houses are still there. The fourth became the permanent standalone homes. These permanent standalone homes were in the rural homes and they came into the towns. Now, in the village, those are the structures in the villages. Mansionettes have been built there, high-end homes now are there. Our focus today is not about the traditional homes. We are talking about how homes within the cities, homes within Nairobi. One, there are standalone homes in Nairobi. If you go to Karen, if you go to Muthaiga, if you go to Runda, you'll get a compound fenced and one house inside. That one has no issue. A title deed can be issued by that. Then the second phase is what now came to be called apartments, where people are now building homes vertically, upwards. Originally, people built on the ground. Today, we have high-rise buildings. And in those high-rise buildings, you'll get a building that has 20, 30, 40 floors. If you go to New York, if you go to Dubai, if you go to France, you have buildings that have more than 100 floors. Each floor has apartments. And those apartments, people have bought them as homes. The traditional hut where somebody was a dwelling house, now somebody is on 150 floors. That is where they call home. The title deed originally was one on the ground. Now, out of that one on the ground, the law under Sectional Properties Act provides for title deeds in every home, every apartment, up to if the building is 100 floors. We have also offices. Originally, the office was a ground floor. Today, you have an office on 14th floor. That space you will buy, you will be given a title deed for that space that you have bought. So the question that today we are dealing, when we are dealing with this new concept of homes and title deeds, we have also found estates, what we call the gated community. The homes are not gorofas. Each person has a home with a compound, but the entry is one, the security guards are one, the facilities are given together. The new concept of a common area comes in. Traditionally, there was no common area. What was a common area was a common playing field and a river that was common for people to go to fetch water. That area was common to everybody. Everybody's cows could come in. Now we have a new concept of a common area. The common area in this new sectional property are the staircases, the lift. Remember, the lift is not yours. The lift serves everybody. The staircases serves everybody. Those are the staircases. The balconies of the staircases serve everybody. Lighting on these staircases. These staircases, the lift, and other common facilities, for example, the playing field, the parking yard for the cars, those are common areas. Dumping site for garbage collection, those are common areas. The generator that serves this area is in a common area. The sewage from each apartment is in a common area. All these things are used by everybody. The security lights outside are used by everybody. So this common area, how is it going to be managed? That is the most contentious issue. Number two, the title deed, the ground title deed that has the land holding the building is called a mother title. The mother title of this plot must be surrendered to the land registry for the land registry to issue title deeds, certificates of title to all these people, 1,000 of them. They must be given a title deed, each called certificate of title from the mother title deed. Who is going to have the title deed for the common area? The common area requires employees to do this work. Cleaning. The security guards must be in place. The people who repair security must be paid. Kenya Power must be paid for the electricity for the security area. The water that cleans this place, Nairobi City County or Kisumu City County or Mombasa City County, must be paid for the services they are offering of water. The drainage, the sewers, the county government must be paid for this. So the question is, how does the law provide? Most of the tall buildings are constructed by Chinese or a JV, that is a joint venture. The owner of the land is an African Kenyan. He is dealing with the question of a foreigner who has brought money. They build this land. Who will manage the common area? Very many developers are managing this common area. People are being told you pay service charge every month of 10,000 shillings, of 20,000 shillings. You are 500 homeowners. Each is supposed to pay 10,000 shillings. That is 5 million shillings to deal with a common area. The developer does not give you accounts how this money has been applied. You are a single man. You come, you've bought an apartment. You only go there once because you work for the UN. You are all over the world. Are you going to pay the same service charge for electricity, for sewage, for others, and somebody has 10 children in that one place? These are the issues. Many people are fighting. The homeowners are fighting with the owners who bought this land. The people who bought the properties have no rights. This is the question that led to the filing of the case. That is in the Environment and Land Court at Nairobi. Justice O.A. Angote in petition number E063 of 2022. The case was between George Kanyi, Stanley Kimani, Sanjay Shefchi, and Alexander Mwema. They sued Next Gen Office Suites Limited. They sued the Chief Land Registrar, the Principal Secretary, Ministry of Lands and Fiscal Planning, Ministry of Lands and Fiscal Planning, and the County Government of Nairobi. What was the issue? The application is supported by the grounds on the face of it and the supporting affidavit sworn by George Kanyi. And he said they are purchasers of units in the property known as the Next Gen Commercial Center Mall. And they said the plaintiff that no management company has been established with the membership drawn from the unit owners to manage the affairs of the common property, and that if this court does not intervene by granting conservatory orders, the substratum of this suit will be extinguished. They went to court saying that under this law, a management company must be registered to manage the common area. What does the law provide? The judge in paragraph 24 provides, he says, the Act, that is the Sectional Properties Act, provides for the division of buildings into units to be owned by individuals, proprietors, and common property to be owned by proprietors of the units as tenants in common, and provide for the use and management of the units of common property. The judge is telling everybody that the Act provides for the division of the building into units, number one, which will be owned by individual proprietors. Number two, the Act provides for common property, which we have defined, which is to be owned not by the owners, not by the developer, not by the people who developed and sold, but by the ones who bought the property, called the proprietors of these units, as tenants in common. And they should provide for the use and management of the units and the common property. He goes on to say, the regulations that were put in place operationalized the Act and the procedures for registration of the sectional plans, the conversion of long-term leases, and the common area usage. So this is what the Act was put in place for. In paragraph 29, the judge says the Act requires that a sectional unit owner's interest in the common areas to be endorsed on their certificate of title or certificate of lease as applicable. Each sectional unit owner will be responsible for payment of land rent and rates for their individual unit. The common areas are owned by the sectional unit owners as tenants in common in shares proportionate of their units. And the management corporation manages the common area on behalf of the unit owners in accordance with the provisions of the Act and by laws adopted by the members. So the judge is saying the common area is to be owned by the owners who bought the units. If there are 200 owners, they are the owners of the common area, not those who build the company. It is them to form a management company to manage, but they'll have to pay for that. Paragraph 30. The judge says, once the corporation under this act is registered, the management company is required to transfer all its assets and liabilities to the management corporation within 1 year of registration of the management corporation. So the owners, the Chinese and those who have built the buildings form a management company. Within 1 year, they must register a corporation management company. A corporation is of owners of the building, the owners of the individual units, and they must transfer that management company that was owned by the Chinese, that was owned by the Italian, that was owned by the one who built the building, and hand it over management to the new owners, the 200 of them. Paragraph 30. It says, once the corporation under this act is registered, the management company is required to transfer all its assets and liabilities to the management corporation within 1 year of registration of the management corporation. The management company will then be wound up in accordance with the Insolvency Act. So, what did the judges find out? The judges found out that Section 17 of the Act provides for the incorporation of the corporation, which provides on the registration of the sectional plan. As the owner, the Chinese, the owner of this tall building, registers the sectional plan with the mother title, there shall be constituted a corporation under the name the owner's sectional plan number. And I repeat, the owner's sectional plan number, into brackets, the number to be specified being the number given to the plan on registration. Number 2, the registrar of lands shall issue a certificate of registration of that corporation. 3, a corporation shall consist of those persons, 1, who are the owners of the units in the parcel to which the sectional plan relates. The individual 200 owners who bought will be the owners of the corporation. 2, those who are entitled to the parcel when the sectional arrangement is terminated under this, the 200 people who are bought. 4, the corporation shall have perpetual succession and a common seal. 5, the corporation shall be regulated in accordance with this act, and the bylaws specified in the regulation shall subject thereto have effect in relation to the corporation and its board. These owners, the 200, will sit and make their bylaws. The bylaws will be registered, and those are the constitution that will govern the common area. The judge says, Section 27 of the Sectional Properties Act provides that when a developer registers a sectional plan, he shall within, and this one, my good brother Cyrus is very attentive, he shall, the owner of that building who has built 100 floors, shall within 90 days from the day that 50% of the units are sold, the owner or the developer of the sectional plan, number one, he shall within 90 days from the day 50% of the units have been sold. If the units are 200, if 50%, that is, if 50 units, if 100 units have been sold within 90 days, what will the Chinese do? Or 180 days from the day that the first unit is sold. If the 50% are not sold, not all of them are sold, 180 days from the day the first unit was sold. So if Bramwell bought the first unit, 180 days have expired and no any other unit has been sold. Or if 50% have been sold, the 90-day is triggered. If 50% have been sold, but Cyrus has bought one unit and 180 days have expired since Cyrus bought it, what happens? Very critical. The developer will convene a meeting of the corporation at which a board shall be elected. Whether it is one person, whether there are more than half, a meeting shall be convened of the individual owners. And remember, we have given Cyrus as the only one who has bought. He'll be called and a board, a corporation meeting will be held and the board shall be elected. Section 28 provides that the board shall, once every year, convene an annual general meeting of the owners. That board every year will convene an annual general meeting of all the individual people who are the owners of this building. The judge in section 62 says, my understanding of the above provision is that the membership of the corporation is not dependent on whether the developer has sold all the units or not. So the developer does not need to sell the whole of the buildings. Cyrus alone, who bought one, is sufficient to be the corporation. 2 people, 3 people, 10 people, 20 people who have bought, so long as 90 days passed, if they were over 50%, or 180 days passed from the day the first person bought the house, the corporation is legitimate. He moves on. 62 says the owner of the units become shareholders. Those, if Cyrus and the others who bought that apartment, they become now shareholders. Depending on the number of units they purchase, the moment the leases are registered. in their favor. Indeed, the law allows all the members of the corporation to participate in the election of the board and in the daily runnings of the premises through the board. The board runs the common area. The day-to-day running of the common area is in the board. The board is elected yearly by the owners, the developer. That person who developed the building is nowhere. He developed, he was paid, he should leave. He has no control. Many Kenyans are crying. They are being exploited billions and billions of money through what is called service charge. The developer developed, he sold, but he doesn't want to relinquish the management of the common areas to the individual owners. The judge says in paragraph 64, under the law, it is the duty of the developer to undertake the process of conversion of the leases under Section 13 of the Act and Regulation 18 of the Sectional Properties Regulation 2021. If it has not been done so, and to have all the persons owning units in the premises to be shareholders of the corporation, including these people who went to court fighting to take control of the management of the common areas of NextGen, and which company will have the sole mandate of managing the operations of the building, including managing the common areas as stipulated in this Act. Indeed, under the Act, the sectional plan for the premise should be accompanied by an application for registration by the corporation and a list of the persons who are owners of the units, and not the first defendant, not the developer. What this means is that until the corporation is registered in the names of all unit holders as shareholders, the process of converting the sued property into sectional units cannot commence. Kenyans, until the corporation is registered, your property you bought as a sectional property unit cannot commence registration. So now you know why you have paid, you have finished what you are supposed to pay, you don't have a title deed to your property. 3 things must be done before you get. 1, a sectional plan that will be taken to the registrar together with a corporation of the owners of the building, the owners of individual properties, and a mother title to be submitted to the registrar. 3 things are mandatory. If those things are not there, you will never get your sectional title. You'll never get it. Did the developer obtain money from you without disclosing this? If there is no mother title and the mother title is in a bank, you'll never get your title. If number 2, they have not registered you as owners into what is called a corporation, you cannot get an individual title deed. 3, did these people lie to you? Are you managing the common area? What did the judge give as final orders? For those reasons, the plaintiff, who are the individual owners of the building, made an application dated 11th February 2022. It was allowed as follows. Pending the hearing and determination of this suit, the plaintiff be and are hereby granted leave to incorporate a corporation of next-gen commercial center erected on LR number 209/18648 Nairobi, with membership and ownership drawn from all owners / purchasers of the units of next-gen commercial center erected on LR number 209/18648 Nairobi, to manage the affairs of common areas and common interests of all units, owners / purchasers in compliance with Sectional Properties Act 2020. B. Other than the process of establishing the management company / corporation and conversion of all leases into sectional units pursuant to the provisions of the law, the first defendant, that is the developer, the Chinese or who, is hereby inhibited from dealing with the property known as next-gen commercial center erected on LR number 209/18648, pending the hearing and determinations of this suit, dated and signed and delivered virtually in Nairobi this 16th day of March 2023. The Principal Judge, ELRC Court, Environment and Land Court, Justice O.A. Angote, Judge. What does the import of this decision mean? You have the power, even if you don't have the sectional property title, to register a corporation. You have the power to call yourself, register a corporation, take it to the registrar of lands, you'll be registered, whether you have a title deed or not. So, two, the developer, the man who bought the land, built the structures, you bought him, has no responsibility to charge you rates, to charge you service charge, to charge you manage fee on how you manage your common area. That is the preserve of the owners of the building. 3. Whether the building has not been bought complete, if 50% has been bought, we have found that the law allows, if 50% have been bought and 90 days have expired, you can form your corporation, those who have been bought, and you start managing your common area. Lastly, if only one unit has been bought, not 50%, the one we talked of, Cyrus. If one unit has been bought and 180 days have expired, you have the power to form a corporation, registered, and manage the common area and manage service charge. Wakili Danstan Omari is telling you the law protects individual buyers. You took a mortgage, you took a loan, you sold land somewhere, you bought, you are not given the truth of this matter. Suppose in the sectional property that you have bought, we shall be dealing with in the second episode about sectional property. We know many Kenyans have been cheated that the property has a swimming pool, The property has a pool that is warm. The property has a generator, standby generator that runs 24 hours. The property has Wi-Fi. The property has piped gas. The property has a common area for TV, a lounge. We shall be doing a second episode on sectional property, why you can't to buy a property not fit as per the prospectus that you are given. Can you redress what you are doing? Many people have bought these sectional properties, apartments for business, Airbnbs. Your customers come in, there is no Wi-Fi. Your customers come in, there is no cleaning facilities. Your customer comes in, there is no water, hot water. Your customer comes in, there is no light. The windows are so small. Your customer comes in, the garbage is falling from top to where you are. We shall bring to you. Court and Copter will always bring to you the law as it is. As an investor, the law, the Sectional Properties Act, protects you. Your rights are protected. Section 7 of the Criminal Procedure Code, the Penal Code says, ignorance of the law is no defense against the law. The developers cannot feign that they were ignorant of the Sectional Properties Act. Now, Wakili Dan Senomari has brought it to you, the law itself. Don't sit on your rights. Don't sit on your rights. You have invested in an apartment. The property that you have invested must be marketable. Wakili Dan Senomari from Court Helicopter News, bringing it to you over the weekend. Enjoy your weekend. Thank you.